Aka.
Good morning.
Mr. Tinker, do you have your camera on? There he is.
Morning.
Okay, Mr. Tinker, you're up.
May it please the court. Good morning, Your Honors. Mark Tinker on behalf of Security First Insurance Company. I would like to reserve 3 minutes.
Sure.
Something interesting struck me preparing for this morning, looking back through the briefs. Both the initial brief and answer brief begin with the sentence that this case is straightforward. So I think we have that going for us at least. But I think it is because the facts are agreed with the parties. We know the facts of loss. We know what the policy says. We have the language in front of us, and it's a purely legal question for the court. And I think that the interesting thing that's quite telling is what the trial judge did with that language in this case. The first time that he looked at it, he read the endorsement and just looked at the policy and applied the plain language of it. We have a loss where there's a piece of plumbing, a cast iron pipe that failed. It leaked water behind the wall, causing some damage. The policy endorsement they looked at says we do not insure for loss caused directly or indirectly by water damage, meaning discharge or overflow of water from within a plumbing system. And he said that applies. It excludes the coverage. Now, then it went back on rehearing, and what the judge did the second time is took the policy and the argument presented to him that he adopted in his order granting the rehearing involved a convoluted analysis where he started deconstructing the policy essentially.
And he looked at other parts of the policy?
Well, he did even more than that, Your Honor. What he did was he took the base policy and took the endorsements off of it and said, I'm going to look at the base policy, but I'm going to add in the Florida specific rider. So he's not adding in all the endorsements, added in the Florida rider to look at that coverage, compared that coverage to language used in a personal property endorsement or personal property coverage that's not at issue, and a part of the personal property coverage that was eventually deleted. So it was never even in the policy that was issued to Mr. Estrada. So he compared that language and did what he phrased as a snapshot in time to say, here's what I think.
Let me ask you this. I just want to make sure I understand your right. So if the trial court was trying to determine what effect the water damage exclusion endorsement had on this policy, the trial court was supposed to ignore the Florida endorsement?
No, Your Honor. I think he was supposed to read all of them, including the Florida endorsement and the water damage exclusion endorsement. What he did was he took the exclusion off, looked at just the Florida endorsement, and compared it to a property damage coverage, a personal property damage coverage that did not even exist. The provision that he looked at wasn't even in the actual policy once the other endorsements were added back on. So he looked at that partial policy, did what he phrased as his snapshot in time analysis of what it would have covered and then added the endorsement back on and said, well, I think by doing all of this, the word discharge doesn't really mean every single form of water emitting from pipes. It doesn't include a slow long-term leak, which is what we had here. So he took what he originally said when he just looked at the policy in general and said, this does not apply to a discharge or overflow of water from plumbing. Once he went through that entire analysis, said, well, discharge doesn't mean discharge anymore. Discharge now, it must have a flow rate or a timing aspect to it because it doesn't apply to seepage or long-term slow leaks. It only applies to something else.
Sorry to interrupt you. I'm following. But so
Absolutely.
In other words, what you're saying is the water damage exclusion endorsement removed the portion of the policy that created a distinction between seepage and overflow and discharge?
No, Your Honor. What the water damage exclusion endorsement did was it modified just essentially the definition of water damage. There was always a water damage exclusion.
So if that didn't happen, so if it didn't do that, wasn't the trial court permitted to recognize that the policy recognized the distinction between seepage damage and overflow damage?
Right. The policy doesn't have a distinction there. What the policy does, as far as if you're looking at, I mean, we go back to the beginning. What is the definition of seepage? And what's funny is that the trial judge said it doesn't cover all water emitting from plumbing. That's right in it. That's the language he chose in his order. And I think we put about 6 dictionary definitions in the briefs. Every single one.
I understand you both have referred to the dictionary and discharge, is the, I don't know, phylum, I'm getting into biology, but species, phylum, et cetera. Okay, and I understand that that's relevant, but my question is, when was the judge permitted to recognize that the language as used in this contract recognize a distinction between two types of water emitting from plumbing? And I'm wondering, was not after the special endorsement was added, excuse me, the water damage was added, there still remained provisions that underscored a distinction between those two types of water emission. Is that correct?
No, Your Honor, because the seepage, when you look at what that seepage language is, it's not just that single word. You can't take the word seepage and the word discharge. Seepage is tied to long-term seepage of 14 or more days, constant and repeated seepage of 14 or more days.
I think seepage is used elsewhere in the policy, if I'm not mistaken, too. I mean, the policy, uses seepage, and as Judge Atkinson pointed out, it uses them differently. It doesn't seem to view them as the same thing. I don't know.
Well, Your Honor, I think the test that we have to go back to is, what is this confusing to a layperson reading it? If you read the sentence, discharge of water from plumbing, are you confused by that? Do you think that it has to be slow or fast? Do you think it has to be a certain flow rate or volume? You know what a discharge of water from plumbing is. And that's when the judge read it the first time, just looking at that endorsement, that's exactly what he found. He said, that's unambiguous. I know what a discharge of water from plumbing is.
I'll tell you what, if I read the whole policy, I would assume there's a difference between discharge and seepage.
And, there's any of these similes that you could put in there, whether water was, gushing out, we kind of know that means, I guess that's probably fast. But when
my read of this, you read through the whole thing, you have to do some cutting and pasting because they keep substituting things. But when you read through the whole thing, I'm like, well, they're looking at two different things here. They're getting at two different things. I'm not sure what they're getting at, but it's definitely two different things.
And when it comes to water, when it uses the term seepage, in order to differentiate that as from anything else, it makes it a constant or repeated long-term seepage of water. And then discharge doesn't have any of those timing or flow rate aspects to it. And if you're looking at the entire policy.
I'm sorry to interrupt, but let me try to restate what I said. When I read through this policy or any insurance policy, there's exclusions, there's coverages, and it's written in this very generic language, but it seems clear that the insurance company has some scenario in mind when they create exclusions or exceptions. Like, we're thinking of some particular kind of event, but we're not going to name that because we want this broad exclusion or exception, but that they've got something in mind that they either want to cover or not cover. And so when I would read through this, I would not necessarily think that water damage meant anything, because there's these other water provisions that seem to encompass some other type of scenario. Maybe it would be helpful if they put in, for example,
Discharge.
I think it's not as clear as you're trying to argue that it is. That's all. So you've got an uphill battle. Go ahead.
Discharge or overflow of water versus constant or repeated seepage or leakage of water.
And
what you're getting at, Judge. I think, Judge Kelly. Don't let me put words in your mouth.
Yeah.
I just did.
You're going to say it better than me, so please.
Well, I don't know about that, but I'm repeating it from my own understanding, really.
Yeah.
So sorry, Judge. Sorry, Mr. Tinker.
That's all right. And I think, again, this is going into dissecting it. You can find ambiguity anywhere you want if you try hard enough. And, you can go to the classic example of, President Clinton defining the word is. You can find ambiguities anywhere. What we have to do is go to what the judge did the first time, and he just read the plain language of the policy. Is this a discharge of water from the plumbing? Yes, it is. Now, when the policy does, we've had these, the discussions about flow rate and everything. If you look at other portions, like look at the smoke damage, that says sudden and accidental smoke. So that puts speed on it versus the seepage is, is constant, repeated over 14 days. So it adds language to tell you that when I'm using this simile for water emitting from a pipe, is it slow? Is it fast? The policy knows how to do that. It says sudden for some things. It says 14 or more days for others. So it tells you what that is. The endorsement doesn't add any qualifiers to the word discharge. It just says, is there a discharge of water? Is it slow? Is it fast? Is it voluminous? Is it, whatever it is.
It says discharge or overflow, right?
Yes.
Yes. Correct.
Isn't that similar to language elsewhere in the policy? That's just
there is language like that. There is other language.
Wouldn't Judge Kelly, if this was her policy, think, well, wait a minute, that correlates to another provision that says the exact same language, which is different than the provision in which it talks about seepage.
Well, what you'd be looking at is the only place that the seepage is that's where the coverage is provided for slow or long-term hidden seepage over 14 or more days. So it says, there's a coverage that's provided for that until Mr. Estrada decided to purchase this endorsement and, for a premium savings, got this endorsement that takes these certain water coverages out. And all you'd have to do is say, here's the base policy with the Florida coverages. It covers that long-term 14 or more day seepage. But I decided for a premium credit, I want this endorsement. What does the endorsement say? Any discharge or overflow of water from plumbing. That's something that a layperson would look at, read, and understand. It's a tortured interpretation to go back through and start deconstructing the policy, pretend that endorsement doesn't exist, take a snapshot in time as the judge did, and decide here's what it, we look at this phrase all by itself over here, and then when we add the endorsement back in, now it gets confusing, as opposed to just reading the endorsement and applying it as it's written. And that's what we believe all of the case law, there's all that boilerplate when we do insurance coverage cases that talk about the plain language and plain meaning and giving the policy its entire effect and not finding other provisions to be superfluous or meaningless. And that's essentially what they do, is take this endorsement that they purchased and say, well, that doesn't apply anymore. You have to find it meaningless because it uses a different verb, even though it doesn't have the modifiers with it, the 14 or more days, constant, repeated, all of those things. It's just a plain word, discharge of water. And I don't know that I'd be repeating myself and going in circles if I said any more than that. So I'd just like to reserve my time unless you have any other questions.
You got it, Mr. Tinker.
Thank you.
Okay, Mr. Vaca.
Good morning. May it please the court. George Vaca, Vaca Law Group, on behalf of Mr. Estrada. We're asking the court to affirm the well-reasoned summary judgment that was entered by the trial court in this case. And there are a variety of what Mr. Tinker refers to as boilerplate insurance cases to consider, but one that I think Judge Atkinson and you, Judge Kelly, hit on was the need to review the policy as a whole and to give effect to every word that's used in the policy to the extent you can do so. And that would be one of the things that the judge realized on rehearing that he hadn't done, but was required to do by the law that addresses insurance policy interpretation. Now, I went through this policy literally dozens of times, excuse me. And the first time I saw the concept of accidental discharge or overflow of water is at page 6 of the ISO form. And it addresses accidental discharge or overflow of water or steam from within a plumbing, heating, etc., within the context of landlord furnishings personal coverage.
That's right.
Personal property. That's the first time that that's referenced. The next time that I saw that it was referenced is at page 174 of the record, paragraph 12, again referring to personal property coverage, and it uses the term accidental discharge or overflow of water. That policy also has an exclusion under Section 1 for water damage, and it is a scaled down version of the one that ultimately gets added to this policy. But that's where those terms emanate from, which is from the standard ISO form for personal property. We then go to what is referred to as the special provisions for Florida. And that form is SVIV H0309 SP 1213. Now, the important thing about that is, and I would just like to make a point about this, this is a form that was not created by ISO. This is a form that was created by Security First. And they went in and altered, although they borrowed some ISO language, they went in and altered the ISO form to include words and phrases that it chose to include in the policy. And it is here in this document, specifically at page 188 of the record, where we see paragraph F, in which this constant or repeated seepage or leakage language first appears in the policy. And this language is kind of interesting because first it's an exclusion, which when you look at it and say, oh, that doesn't really make sense, but it's an exclusion. And then they create the exception to the exclusion, which is if the leak has lasted for 14 days or more and the insured has no knowledge of the damage, then the exception to the exclusion would apply. This form also alters the definition of water damage. It includes yet a third category. And then when you go to the provision that Mr. Tinker and the insurance company have been working off of, which is SFIV H0309WD0912, which is the water damage exclusion, it does a couple of things. The first thing it says is, as it pertains to personal property, it deletes paragraph 12, which is what we started out with. And then it adds a new exclusion. It doesn't change the language pertaining to seepage and leakage. It doesn't say wipe that provision out. It doesn't say ignore that language. It doesn't address it at all. And so I think what the trial judge did, certainly when I was looking at it, is, hey, wait a minute. They used two different sets of words to describe what it is that they were excluding. They must have meant two different things. And I think that that's a fair reading of the policy. Of course, if you conclude that that is a fair reading of the policy, I don't have to show that that's the only fair reading of the policy, just that it is a fair reading of the policy. And most respectfully, I think that's what the judge did on rehearing. He thought about it. He went back. He looked at all the words and phrases in the policy and said, you know what? The insured is putting forth a reasonable interpretation. And if that is a reasonable interpretation, even if the argument by Mr. Tinker is accurate, then there's an ambiguity in the policy, and I have to resolve that ambiguity in favor of the insured. And I believe that's what he did. So we've cited the court to all sorts of cases, nothing dead on point. I think the Price versus Castle Key case, although tangentially related, certainly suggests that these terms that this insurance company chose to use in this particular policy are anything but a model of clarity and are reasonably susceptible of multiple interpretations, which is precisely what happened here. So unless the court has some questions for me, we would ask the court affirm the well-reasoned decision of the trial judge in this case.
Thank you, Mr. Baca.
Thank you.
Mr. Tinker, yeah, about 5 minutes.
Thank you. I think really the only thing I'd like to point out is we're treating seepage and discharge, because they're different phrases, as if they're mutually exclusive phrases, and they're not. What the policy does is, in the provisions that Mr. Vaca just went through, it adds in this coverage to say when there's constant or long-term seepage of water or leakage of water, if it's hidden from view behind a wall, then that is covered. And so that creates this coverage that doesn't, not all leaks are covered. This constant and long-term, if hidden, seepage is covered. So it creates this little coverage. And then
you're saying that not all leaks are covered by that provision.
I'm saying what this provision does
doesn't that mean that you wouldn't cover a different type of leak under that provision because there's different types of emission of water?
No, Your Honor. What I'm saying is what this provision addresses, it says if there's a constant and long term for more than 14 days and hidden, it creates that coverage. So we're taking that language to say that's a seepage. And then when the insured buys the endorsement or gets the credit for the endorsement, and the endorsement says, now we're going to exclude any discharge coming from the plumbing, because that's a different word, that doesn't make it mutually exclusive. It's any discharge, including seepages, including leaks, including squirts and flows. And, it's not mutually exclusive just because it's a different word. And if you look up, go back to the same definitions and things that we've used, and even the U.S. Supreme Court from the S.D. Warren case looked at the same thing and said, here's our definition of discharge. And it's the same thing. It is anything that is flowing or issuing out. It doesn't say anything about how fast, how slow, how long it takes, doesn't any of that. And so just because it's a different word doesn't mean it does not apply, doesn't mean it doesn't encompass that. And if you're looking at that as an exclusionary endorsement, if it conflicts, the endorsement controls over anything else in the policy. So we have this coverage that exists for slow and long term if it's hidden, little seepages or leakages. But when you buy the endorsement, you get the credit for the endorsement and add that in, it excludes any discharge from a pipe. That can be the seepage discharges, that could be leak discharges, anything that's coming out of pipes, any discharge of water or overflow of water from pipes. So different terms, that does not mean they're mutually exclusive, and any layperson reading that endorsement would do as the judge did the very first time around, say, well, you had a leak of your pipe, this endorsement excludes coverage for discharges of water from your pipes. That's all there is to it. I'd go back to my very first thing that we both started the brief saying this case is straightforward, and I think it's no more difficult than that. It doesn't need to be any more difficult than that. Unless you have any other questions, I thank you for your time.
Thank you, Mr. Tinker. Let me say, as long as I have known you both, I never imagined we would be looking at each other through video cameras. I think we've all done quite well, if I say so myself.
Well, thank you.
The court will be in recess for 10 minutes.